want to make sure, just in the way of background, the case, of course, does involve the City of Austin's proposed new land development code, comprehensive zoning statute. There's a lot of substance to that code, and this lawsuit is not really directly concerned with that substance. It's concerned with the procedures by which the city is attempting to promulgate the new land development code. And, I will certainly commend our amicus briefs for the court's attention. I think that they're very well done, and they're done on behalf of the Austin Neighborhood Council, which is an association of 80 different neighborhood associations within the city of Austin. The NAACP, with whom we're all familiar, they're concerned with the issue of gentrification. Bipolar, which is an East Austin social justice organization led by women of color, and by Development Not Displacement, which represents, according to the brief, represents vulnerable neighborhood versus secondary gentrification and displacement of low income and communities of color. Harm has already been done. The city has refused to entertain protests, and they're very much on record with that. We have memoranda from Assistant City Attorney Brent Lloyd. Zoning protests may not be used for this. We have a May 2nd memorandum and a May 14th memorandum from another person in the city's law department, Mitzi Cotton, to the same effect, that zoning protests may not be used to trigger a supermajority vote on broad legislative amendments, including comprehensive revisions, which is dead wrong under the law. So the city is, well, and in fact, on the city's website, it's another thing we complain about, they have specifically in their question and answer portion of it posed the question, as a property owner, may I file a protest to the zoning changes being proposed under the land development code? City's answer on the website, no, zoning protests may not be used to protest broad legislative amendments. Again, we think it's dead wrong. So there's been a chilling effect already. That some city council members filed motions to honor protest rights. Another motion to wait until the court's ruling determined the issue, the legal issue of protest rights and notice. And both of those motions were defeated in city council by a 7-4 vote. And there is no exemption in the statute for comprehensive zoning. In fact, comprehensive zoning involves, first of all, you can't have two zoning codes. You can only have one. So if you're going to adopt a comprehensive new one that replaces the old one, you got to repeal the old one. You may pass an ordinance that says it's repealed, but you don't have to. It would be repealed by implication if it were replaced. The city has passed an ordinance. It's section 25-2-241, distinction between zoning and rezoning. And this, the cities do this to complement state law. They can't change state law. They can't detract from state law, but of course they can add to it, add to its requirements if they want to. So in the city ordinance, they say zoning is the initial classification of property, part one. Part two, rezoning amends the zoning map to change the base district classification of property that was previously zoned. Rezoning under their own city ordinance, just like it is under state law. And we think that the defendant's argument in this case does violence to the language of the statute, misstates the holdings of the cases, both theirs and ours, creates a whole lot of rabbit trails through the woods, is what I call them, on what much of the evidence is totally irrelevant to the legal issues. They say it's too hard. We say it's not too hard. And if it is too hard, it's their fault. They made it harder than it needed to be. So let's start over and do it right.
When I say comprehensive, what I mean is that the changes to be implemented in the LDC revision apply as a categorical matter. They apply uniformly north to south to east to west within the city, across districts, across boundaries, across neighborhoods. They are implemented by text, not by map, to ensure that they apply equally everywhere throughout the city. Is a zone conversion table. Mr. Becker's exhibit had a piece of this, but I'd like to talk a little bit more about it.
Let me just stop you for a second and ask you, so
Yes.
it is true then that the new Title 23 will be adopted and the old Title 25 will be repealed?
It will not be repealed. It'll live there for various reasons not germane to the issue before you today. It will be superseded by Title 23, but Title 25 will sit there as a kind of as a zombie. It will not be formally repealed.
Oh, gosh. I'm not sure I understand the difference between superseding it and repealing it.
The new provisions of Title 23 will control. They will prevail and control and be an entirely new land development code. Title 25 will not be repealed completely, because if we repeal it completely, that will wreak havoc for grandfathering purposes. So it will continue to exist, and the changes that are going to happen to zoning in the city do not impact any given property or area or district or neighborhood any different from any other property anywhere in the city. So if you look at these, Mr. Becker referred to, say, the SF5. Every SF5 in the whole entire city of Austin will become an R4. Each and every one, whether it's in Clarksville or Hyde Park or Dove Springs or Circle C or Northwest Hills or wherever it is, every SF5 will become an R4. That will change its uses.
And what the graph that Mr. Becker handed me shows is that the SF5 now has something under 20 units per acre, and the new R4 will have something in the neighborhood of 70 units per acre.
Yes, Your Honor. Well, I don't.
So that it is a substantial change. Your point is simply that it's a change all over the city and not just to one part of the city.
Precisely correct, Your Honor. Each and every SF5 property in the city is treated exactly the same as every other SF5 property within the city.
So whether it's in central Austin or in the suburbs, if it's within the city, it will go up to 70 units per acre.
Whatever R4 is. And the whatever it is, it applies uniformly across all neighborhoods, across all boundaries. And the reason that's significant for the purposes of the issue you are deciding here today, Your Honor, is that no given property within the city is uniquely affected. All of us, every SF1, every SF5, every SF4, each and every one of those properties is going to have the same conversion rules apply.
Why does that matter? It may bother some people more than others. It may, people who are in one part of town may be more concerned about it than others.
Here's why it matters, Your Honor. Because the individual written notice and the protest provisions in the statute exist to provide procedural protections for properties who will be uniquely impacted by zoning changes. And I'm going to skip ahead and I'm going to talk about that right now, because that's obviously something that you are.
So if you harm everyone the same, then nobody should get the protest?
Well, and what he says about changes and when there should be a 3/4 vote is he says that ordinary routine changes can be adopted by a majority vote of the local legislative body, but requiring a 3/4 vote in the event of a protest from a substantial portion of property owners whose interests are affected. So from the very beginning, the protest provision has focused on who are the property owners? What are the properties whose interests are affected? Let's give them extra procedural protections. So that lives in the Standard Act. That same concept, the city of Frisco adopted a zoning change. Mr. Becker said, oh, it's not really a zoning change because it's just requiring a distance from how far from schools, hospitals, churches can you not sell alcohol. Well, what zoning is regulating the use of land. That's the operative ordinance. That's an ordinance that's adopted by the city that amended their city code and added a paragraph prohibiting the sale of alcoholic beverages within 300 feet of a church, school, or public hospital.
But there is a phrase set out by dashes that say, that sentence says, they enacted a new ordinance which amended Chapter 10 of the City Code, not the city zoning ordinance, by adding a paragraph prohibiting the sale of alcoholic beverages within 300 feet of a church, school, or public hospital.
General purpose of notice provisions in the zoning context is to protect individual property owners from municipal overreaching. So
Well, and so your argument essentially is if only a relatively small number of property owners are impacted, then they have the right to notice and to protest. But if a huge number of property owners are affected, then they don't have the same right.
treating it in a different way, treating it more like initial zoning rather than individual tract zoning makes sense for a couple of reasons.
Let
First,
me just stop you and say,
Yes, ma'am.
if that's what the legislature intended, why didn't they have one provision that applied to the adoption of original zoning ordinances and the adoption of comprehensive revisions to the zoning code, land development code, and then one for what you call spot zoning. Instead, the first part only applies to adoption of original zoning ordinances.
well, you're right, Your Honor. The statute doesn't specify the difference between the two. There's a comprehensive, there's the initial zoning, and then there's the individual written zoning. McDonald. Brenda McDonald is one of the authors of Mixon. She's one of the current authors of Mixon. She is an expert regarding land use regulation in the state, and she is both advises cities as outside counsel and also serves as city attorney for a number of smaller cities. And she explains at paragraph 13 of her affidavit, she explains that a number of Texas cities in recent years have done what the city of Austin is doing right now, have undertaken comprehensive revisions of their land development codes, including their zoning codes. She lists a bunch of them there, including some right in our area, Round Rock, San Marcos, Marble Falls, also Denton, Frisco, and all of those cities are following the exact procedures that the city of Austin is following.
So apparently there's nobody suing them.
FLCT case.
Right, but that wasn't a comprehensive revision of their entire land development code. That had to do with.
Not in that case, Your Honor, but the published notice, not individual notice, and then not having protest rights at the back end that is how all of these cities have handled the comprehensive revisions, and that's also how Mixon says it's appropriate to handle it, and that's also consistent with the FLCT case. And also, Your Honor,
Well, I would be much happier if somebody had sued them and there were a law that I was required to follow on that. But apparently, none of those have made their way to either the Austin Court of Appeals or the Texas Supreme Court.
none of those have, Your Honor. But what I hope that you will see that applying the individual written notice and protest provisions to a comprehensive revision of the land development code would be absurd. And that indicates exactly why those provisions are not applicable to a process like this. The purpose of it is is implementing community-wide policies
And
that
that's
sometimes
what
are in
that-
tension with each other.
Let me just say, that's why I'm having a hard time understanding why something that affects hundreds of thousands of people instead of a small handful of people doesn't deserve the same level of notice and protest.
We don't have, what you and I and all of us don't have, is a veto over the legislative process of the city of Austin. And that's why.
Well, and let me just say this, playing devil's advocate. So what you're saying is, if I as an individual property owner have some rezoning that's just me or just a small number of people, and I go in and protest, then that forces the city council to approve the change by 3/4 vote. But if I as a property owner, along with hundreds of thousands of other property owners around the city, don't like the zoning change, I can't force a 3/4 vote of the city council.
That's correct.
And I guess I need to understand why you think the law supports that position and why you think the policy of that is.
Well, Your Honor, the statute is what the statute is. You may think this is a dumb statute. You may think it strikes the right balance. You may think it's good policy, bad policy. But the fact is, that's what it does. That's what the purpose of the individual written notice and protest rights is to protect individual properties or discrete areas. And that's how they apply here. And the protection for all of us is through our city council, is through our elected officials.
Let me just stop you for a minute, because you're calling it individual written notice and individual protest rights, but that's not what the statute calls it.
You're right. They don't call it individual written notice rights. I use that as a shorthand. There's nothing about it that makes it apply to a comprehensive revision. That word comprehensive isn't in there.
The word individual isn't in there.
That's true. The word individual is not anywhere, even in the urge you to follow that path and deny application of the statute to the comprehensive revision of the land development code.
From Mixon is, quote, comprehensive revisions can with equal logic be viewed as reclassifications in that they will reclassify some tracts. Landowners in reclassified areas and within 200 feet therefrom can reasonably claim that reclassifications resulting from comprehensive revisions are ineffective unless the zoning commission gives specific notice by mail and the governing body adopts by a 3/4 majority in the event of protest. They change the density, the height, the setback requirements, etc. for every property in Austin. Or nearly every property in Austin. So, if you look at the charts we have attached to our reply brief, what you see is the huge changes. And it's not just one for everybody. Ms. Weber's arguing, well, these are just across the board changes. They don't affect particular people uniquely. Well, if you look at the chart we looked at before, you'll see that 4 different people can be zoned single family, and even single family 1, let's say. But they're not all being rezoned the same. They're being rezoned differently. And we have that set out in the brief. And you know, I have what I describe as a tearful note from one of my clients out there. You know, what are they talking about that we're not unique? We're all uniquely affected, and the changes on this are large, and they're different for people who are fairly similarly situated. There's no comparable equivalence. People who are zoned single family have a whole range of rezoning that might be, that they're going to be subject to. So it's like I think I heard you say before, if the city's position is that, well, if they're rezoning 95% of the properties, individually. Well, that's adjudicative, and so we have to give notice, and there has to be protest. But if we rezone 100% across the board, well, we don't. Well, if you want to talk about an absurd result, I think that's one. The other problem with that argument is many of the cases say all zoning is legislative, regardless. And so the city wants to draw a distinction between legislative and adjudicative. The adjudicative part being the fact-based part. This is just changes to the text. Okay, it's not just changes to the text. It's changes to the maps as well. But to take your argument and run with it for just a minute, the transcripts of the city council meetings on second and third readings are part of this record. And if you look at those transcripts, you see all kinds of discussions and references to specific properties and to specific areas. The city council members are elected representatives. That's the definition of a politician, I think. It's their job to be responsive to those whom they represent. And as you know, we have districts in the city of Austin. So you don't think those council members on that dais are talking about things they want to change that are affecting their own constituents uniquely, in their opinion? They do. Those discussions are tremendously fact-based, adjudicative. That's just the label. The truth is that under the law, they're all legislative, and all of those changes should be subject to the notice and the protest provisions unless they go the route of a joint meeting. Finally, I have I don't know how many times I've read the 4 subsections of the local government code that apply. I'm sure it's 100. And the first time I read it, I thought, this can't be right, what the city is doing. It's the plain language of the statute. And it talks about repeal. And I understand, honestly, I didn't really follow Ms. Weber's argument about why this is not a repeal. To me, it's a repeal as a matter of law. And there was something about, well, we can't really repeal it because we need to grandfather certain things. You can grandfather people based on a prior statute, even though it's repealed. I think it happens all the time. So it's not necessary. She's making that argument because if it's a repeal, boom, she's under Section 211. An amendment, a repeal, or other change. So she wants to say it's not a repeal. It's a repeal by implication. But even if it weren't, or other change of a regulation or boundary, the new land development code is chock full of thousands of changes to regulations and to boundaries. So, like I say, I keep reading it and I keep not saying it, seeing it, any way except the way that we're arguing. So I would ask the court to uphold our position, make the city do it right.